Hi, I'm Marixenia Davila from Sherman and Sterling, one of these horrible lawyers dealing with these issues. And I have just a simple question to Hugh. How are you proposing to achieve all these things? And who is going to take on the exercise of performing the 3-step tests that you just mentioned? Thank you. Oh, and sorry, an additional question. Does the Commission envisage adopting a super regulation that would deal with it? Thank you.
Apparently the question is for me, Chairman. What am I supposed to answer? The draft directive is actually on the coffee table. I left it when I arrived. No, it's only a draft. I don't know, frankly. There's one thing I'm sure is we need to bring this predictability to this IoT world. And we don't have it at the moment, and after this afternoon, I can't see it coming. And I can't see also why we should always rely on the courts to decide. It's fine, ultimately parties will go to court. But before that, I would argue there is ample room for clarifying a couple of principles. And also, again, it's not only the European Commission which matters here. Frankly, I really believe we have to understand at the global level those key principles. And to reply directly to your question, if we were to make a legislation on this, I'm afraid it will not be ready for 5G generation, maybe for 7G or 10G, I don't know, but not for 5G.
Thank you very much, and some compliments, Sanders Maastricht University in the Netherlands. Also to the last speaker, the Internet of Things, very interesting proposition where all products will become services. So instead of dealing with the value of technology, you would also need to assess the value of the services connected to any Internet of Things device. The entire business model will change. How do you propose to deal with such issues? And another issue, a bit outside of the scope of this, the topic of this conference, perhaps starting small. What about exhaustion of rights in relation to Internet of Things devices? Wouldn't that be the first step that needs to be tackled before we go into complex issues surrounding standard setting in this area? Thank you.
Can you clarify the point about exhaustion, please?
The issue with Internet of Things devices is that once you sell a device, the IP rights in relation to a product will be exhausted. But in relation to an Internet of Things device where there is connectivity and therefore also a software product involved, which is protected by copyright, there is no exhaustion because the connected device or the connected technology does not exhaust. This is EU law as it stands, so in essence there is no exhaustion of rights. So the right holder will have a continued control even if the device will be further commercialized.
I'll just mention that I think that it is worth being keenly aware that there are a range of business models available. There are companies that will interact with you as a consumer so that you can be sold to their advertisers. There are companies who will interact with you as a consumer so that you and they can part ways and not interact in any deep way going forwards, except perhaps for repairs or updates. And there are companies that will interact with you as a consumer for some combination of these things or something else. And of course, there are many other business models. But I think you might find, if you talk to business school professors or economists around the world, that they don't have agreement on what is, among those different options, the most efficient. And even when they do, it is based on a set of facts about the state of the world that will change when the world changes, as it does every moment. And if the world's changing and the economic views or business views about what is efficient are changing, it must be extremely hard for a wise and publicly spirited government to make a decision to favor any one of those over the others if what they want to accomplish is public interest. If what they want to accomplish is something else, I can imagine a lot of very attractive strategies that a political scientist would describe as political economy, but I don't know that that is what you in Europe or we in the US would describe as good government.
Thank you. I think I need to do that. Thank you. So for the question, I think I could think about the possibility along your question for a hardware modules to be developed, which would be a platform available, which would be, manufactured in large series. And then you would customize those hardware modules by either downloading an application that will enable a certain service to be provided, which is an added value service. Then you pay for it when you actually acquire it, when you download it. Or you could have subscription-based services which come for a certain fee, and that's a different business model, because we were speaking about business model. Let's try to identify those business models. And I can even think about a third one, and there are more, surely, and you tell me over this coffee break, not lunch break, it's already past. The third one is proprietary standard. It's no longer a standard which is interoperable with worldwide, but it is linked to a particular, let's say, service provider, and that either service provider or vertically integrated company comes with their own ecosystem, showing what Internet of Things can provide as a service as a whole. And actually that has been seen with different brands, and you can imagine, and I will not make any publicity here, there is no need for that. The only thing I would submit is that when you touch the service part on that hardware platform, you may enter into patent problems and, as you say, copyright problems, and eventually also standard essential patents when it comes to either open standards with reference to my definition, or to proprietary standards, but then because it is supplied by the one who holds the rights, hopefully, then you pay for the service to the right holder, as in the current business model for, I don't need to mention, but you get the name. Thank you.
Regarding those standards and the interoperability, there used to be an exception under software that allows developers to make short copying or reverse engineering of source code to enable interoperability. As you may know, the agreement on Unified Patent Court has now established the same exception for patent rights. So you can no longer, when the UPC comes into force, rely on patents to prevent interoperability. I hope you're aware of that Article 49. What do you think that will have as an impact on what you're discussing now in the Internet of Things?
Okay, you actually have articulated your question with respect to the UPC regulation, and I do not see necessarily a need to rely on that one, except for those holders of patents that are not members of that particular SDO, where it is agreed that there is collaboration among themselves and agreement on the licensing scheme. For instance, to say that for those purposes that you have identified very wisely, for reverse engineering, learning, academic purposes, but not for commercial usages. And you would agree with me, and I understand your question, you're excluding those commercial usage because that's common practice, and that will fall under the UPC regulation in case there is a dispute. But for the rest, I think we have already the rules inside the SDOs under the IPR policy to allow sufficient rights, both on copyrights and on patent rights, to allow reverse engineering, modifications of the code, and whatever you like for academic and non-profitable reasons.
Well, and keep in mind that these things, these different legal doctrines do not exist in a vacuum from each other. And so at least in the US, even if you were to take off the table any possibility of antitrust analysis, you could find, and in fact, if you go look in the past, people have found, there are actual cases of this, plenty of legal remedies, including, in fact, treble damages, when, for example, a software provider advertises to those who might want to make what some people might call add-ons or companion modules, that they have an open architecture, and those lawsuits were brought as straightforward false advertising lawsuits, because you're advertising to your developer or your potential developer community, hey, buy into our game, play with our clients, and they'll play with you. Play with us, will it be more attractive? You'll get to charge, we'll get to charge. If I change my mind in period 2 and I say, whoa, thank you for making good add-ons to my product, but now I'd like to block you from being in my business, hey, no problem. That guy has a false advertising claim against me, and there are plenty of those in the US that have been brought successfully, and by the way, with treble damages available. So it's just worth keeping in mind that there are many good ideas out there. One size doesn't fit all, and you don't need one size to fit all. And the dynamic interaction among professionals that gives rise to the wisdom to see this diverse range of arguments comes from, I wish I could tell you I figured this out. I'd like to tell you I'm smart and I figured this out. I figured this out not by figuring it out myself, but by having to exist in an environment where I had to listen to others. One of the beautiful things about listening to others is that you get the benefit of their ideas. And one of the limits of different organizational structures is that their incentives are to move forward and not to take diverse inputs.
Coffee?